In episode 74, Compliance, Legal, and Regulatory Risk, we explore how projects operate within frameworks of law and obligation. Every initiative exists in a web of rules, some explicit, others implied, that define what can be done, how it must be done, and what happens if those boundaries are crossed. Compliance risk is not abstract paperwork. It is the discipline of staying within the lines that protect the organization's legitimacy. Legal and regulatory factors influence design, timing, cost, and even reputation. Successful project delivery requires not only technical excellence, but lawful execution that preserves value and public trust. The first task in managing compliance and legal risk is identifying which laws, regulations, and standards apply. This mapping exercise is foundational. Projects often span jurisdictions and industries, each with its own set of expectations. International operations may face labor laws, data restrictions, environmental standards, and import-export controls simultaneously. Early identification prevents costly surprises later. Teams should maintain a compliance register listing relevant authorities, governing statutes, and applicable clauses. Knowing the rule set is the start of mastery. Without it, even well-intentioned teams can violate boundaries they never realized existed. Licensing, permits, and certifications form the administrative backbone of compliance. These formal approvals authorize the organization to operate, build, or deliver within regulated environments. Delays or omissions here can halt progress entirely. Every project should maintain a permit tracker that includes application deadlines, renewal dates, and responsible owners. Certifications for personnel or equipment must also be current. These processes may feel procedural, but they represent legal access to operate. A missed license or expired certificate transforms a business risk into a legal infraction, instantly escalating exposure from managerial concern to regulatory breach. Data privacy obligations now reach across borders and industries. Regulations such as the General Data Protection Regulation in Europe or state-level privacy laws in the United States impose strict controls on how personal data is collected, processed, and transferred. Projects that handle personal information must document consent mechanisms, retention schedules, and cross-border transfer safeguards. Encryption, anonymization, and data minimization are not only technical practices but legal expectations. Ignoring privacy risk undermines trust and invites penalty. Compliance here requires partnership between legal, technology, and operations teams, proof that lawful handling of data is as vital as its protection from threat. Industry-specific obligations further complicate the picture. Healthcare, finance, energy, and government sectors each carry unique reporting, disclosure, and certification demands. For example, a healthcare project may require patient safety audits. A financial one must demonstrate anti-money laundering controls. A construction initiative may depend on environmental impact assessments. Understanding these sectoral nuances prevents one-size-fits-all assumptions. Each regulatory body views noncompliance differently. Some impose fines, others suspend operations. Risk professionals act as translators between project reality and legal expectation, ensuring that sector-specific rules become daily practice rather than reactive checklists. Contracts introduce their own legal and confidentiality exposures, particularly around intellectual property. Agreements must clearly define who owns deliverables, how shared information is protected, and what remedies exist for misuse. Confidentiality clauses should specify duration and scope, while intellectual property provisions must balance client rights with supplier interests. Ambiguity here can lead to costly disputes or loss of proprietary value. Reviewing these elements with legal counsel before signing prevents surprises when products launch or partnerships end. Contractual clarity is a quiet but powerful defense against future litigation and reputational harm. Records retention and e-discovery readiness underpin legal defensibility. Projects generate emails, designs, test results, and correspondence that may later become evidence. Establishing retention schedules ensures that necessary records remain available for audits or disputes while unnecessary data is properly disposed of. E-discovery readiness means that, if required, documents can be retrieved efficiently without disrupting operations. Treating record-keeping as risk control, not clerical work, saves both time and credibility when scrutiny arrives. It demonstrates that transparency is designed into operations, not hastily assembled under pressure. Legal counsel should be engaged early, not just during crisis. Lawyers interpret ambiguous regulations, negotiate contractual protections, and advise on acceptable exposure. Their guidance shapes decisions before they become liabilities. Early consultation is faster and cheaper than legal defense later. Risk managers and counsel should maintain an open channel, regular check-ins, not just reactive consultations. This collaboration integrates legal reasoning into project rhythm, turning compliance from obstacle into enabler. When legal expertise is woven into planning, risk maturity deepens and regulatory confidence grows naturally alongside delivery. Compliance checks must live within operational cadence. Embedding small, recurring reviews into project routines, weekly dashboards, monthly audits, or milestone checklists keeps attention constant. This approach is far more effective than sporadic assessments after milestones are complete. Embedded compliance creates rhythm: identify, verify, document, and adjust. Automation can help, but culture matters more. When teams view compliance as part of quality rather than paperwork, adherence becomes habit. Cadence converts obligation into routine, ensuring that the organization stays ready instead of scrambling at inspection time. Regulatory environments shift constantly. Monitoring watch lists and industry alerts keeps organizations informed of pending changes. Subscription services, trade associations, and government bulletins can provide early notice of new rules or interpretations. A change in reporting thresholds or labeling requirements may seem minor, but can ripple through entire projects. Continuous horizon scanning ensures that compliance plans evolve before enforcement begins. Staying alert turns adaptation from reaction into advantage, allowing leadership to plan updates in calm rather than crisis. Potential violations must be escalated immediately. Silence magnifies liability. Teams should have a defined pathway for reporting suspected breaches: confidential, protected, and swift. Rapid escalation allows containment, self-reporting if necessary, and remediation before regulators intervene. Culture matters here. Employees must feel safe raising concerns without fear of reprisal. A transparent escalation framework demonstrates integrity to both staff and oversight bodies. The fastest way to lose trust is to hide problems. The fastest way to rebuild it is to surface and solve them openly. Documenting the rationale behind compliance decisions protects the organization when judgment calls are later reviewed. Laws often require interpretation, and regulators expect to see how conclusions were reached. Notes on context, advice received, and options considered show good faith. Documentation turns subjective reasoning into defensible record. It also aids successors, ensuring institutional memory survives personnel turnover. A well-documented compliance trail communicates one message clearly: the organization acts with diligence and intent, even amid ambiguity. Training transforms compliance from a legal department function into organizational behavior. Team members at every level must understand their practical obligations, how to recognize a potential violation, handle sensitive information, or follow approval steps. Training should emphasize relevance, not regulation recitation. Interactive sessions, brief refreshers, and case-based examples bring abstract laws to life. When people know the why behind the what, compliance becomes part of identity, not just instruction. Trained teams reduce both accidental errors and deliberate misconduct, turning awareness into daily discipline. Lawful delivery protects both reputation and value. Compliance and legal diligence are not boxes to tick. They are the guardrails that keep progress sustainable. Projects succeed when innovation operates within legal clarity and ethical boundaries. Regulatory adherence signals maturity, reassuring customers, partners, and oversight bodies alike. In the end, the cost of compliance is always less than the cost of correction. The disciplined attention to law, documentation, and behavior transforms compliance from constraint into confidence, proving that trust is not declared, it is demonstrated through consistent, lawful practice. Thanks for listening. For more audio courses, daily newsletters, and more, please visit baremetalcyber.com.